Good morning, and thanks very much, Rebecca, and congratulations on the launch of yours and Dr. Weatherall's book, What If We Could Reimagine Copyright? Sorry, Professor Weatherall. And it is an anthology of 10 thoughtful essays that collectively make for a very forward-looking treatise on copyright. And my thanks also today to the Australian Digital Alliance for asking me to speak today, encouraging me to dare bravely, and to the broader Church of the Australian Digital Alliance membership, many of whom contributed time and effort in making submissions to the Productivity Commission's inquiry into Australia's intellectual property arrangements, and for that we thank you. With my words today, I hope to simply do three things. First, share the lens, as Rebecca said, through which the Commission viewed and analysed Australia's intellectual property settings, especially in matters of copyright. Second, do some of the much-needed myth-busting to address claims made about copyright that on any objective examination are more fiction than fact. And third, and most importantly, convey what matters most in getting the policy settings right here. At the get-go of this inquiry, I actually envisaged our task would be about how policy could grapple with the cocktail mix of technology, adaptability, creative endeavour, innovation and competition. And it did so to a large part. But at the end of the day, all roads led us to one simple truth: to ask and answer what is fair. And when we use the term fair, we're not limiting this just to fair use, albeit copyright exception is the policy that matters most for getting the innovation and equity equation right. Because it's not just about the creators versus the tech giants, and it's not a zero-sum game between rights holders and content users, as some would have us believe. It's actually about school kids, uni students, less tech-savvy older people, less tech-savvy younger people, documentary filmmakers, 55-year-old redundant workers, universities and TAFEs and libraries, trying to teach in a more accessible way, and the cost for anyone down under consuming the creative or innovative endeavour of others. For at the end of the day, out-of-kilter IP settings have and will continue to create a largely silent and growing class of have-nots. So today I hope to connect the dots to the many everyday Australians that stand to benefit from the changes we have recommended to government. For there is an incredibly compelling policy narrative to be had here, one of innovation and agility, but perhaps more importantly, it is also one of equity that we can relate to everyday Australians. For when we relate the benefits of change to many Australians, we kind of know what's fair. So to understand our recommendations, it's important to start at the beginning and think about IP policy more broadly. Got it. And in doing so, our simple truth of what is fair should not be unsurprising. For today, IP is embedded in all aspects of modern daily life. It is actually akin to love. In the immortal words of the Troggs' 1967 classic, love is all around us. Well, so's IP. Because IP affects everything and everyone. And it is for this very reason that IP is a policy exemplar. It puts the public into public policy. And perhaps this is why changes to IP are so contentious, because their change affects everyone. But perhaps it's also reflective of the plethora of reviews and studies into IP policy over the past 2 decades or so. Work that reflects thousands of hours of professional endeavour, smart thinking, angst and millions of dollars. This figure depicts the number of reviews into the IP weeds, and often these have been very tightly focused on a particular sort of IP right, rather than considering a suite of IP rights. And we know that an array of rights is almost always used by firms today and creators to protect expressions of ideas in the modern age. And it is the siloed nature of these previous IP reviews that has rendered them less effective, where the concentrated costs of change are readily accounted for fully, while the diffuse and at times unquantifiable future benefits to the community are considered partially at best. And it's hard, if not impossible, to make good public policy when you're only thinking about some of the public. Only 3 reviews have taken a whole of IP approach in the last 2 decades. Henry Ergas's review in 2000, the Cutler review in 2008, and then us, the Productivity Commission most recently. The Harper Review of Competition Policy explicitly recognised this when it considered IP matters. It's why they recommended the Productivity Commission analyse the IP system from a broad perspective. And the government not only endorsed that recommendation at the time, but sent us an incredibly broad terms of reference, the ultimate public policy circuit breaker. And it's in the Commission's DNA to take such an approach. Indeed, our Act requires us to take a community-wide approach, to look at the IP forest rather than particular trees. Now, the only shackle on the inquiry was the requirement to be bound by the existing international agreements, but not to the extent that prevented us from making recommendations on how to improve them in the future, and we certainly accepted the invitation to do so. And with a community-wide view in our DNA, we invest much in community consultation and transparency. It is very much a you tell us approach to public policy making, where all we actually ask of inquiry participants is to show us the evidence and to be honest. And to harvest this evidence, we held 6 public hearings, hearing from just over 120 inquiry participants. We held 69 meetings with creators, consumers and experts. We conducted 4 round tables. Many of you joined us and helped us with those. And they involved 50 participants. We examined and consulted across 7 different jurisdictions to get an idea about what was specific to Australia and what was not. And this is before even considering the 620 plus public submissions made to the inquiry. Every one of them read and studied, along with our own original analysis, and this is how we establish our evidence base. And because we take an evidence-based approach, we even, heaven forbid, change our minds when presented with compelling evidence. And this can be seen in our final report, where evidence in hearings and the second post-draft report round of submissions did change our mind in areas of business method and software patents, plant breeders' rights, and even in the form of fair use that we recommended in the final report. We conceded, and rightly so, that the smart folk at the Australian Law Reform Commission got the framing of fair use exceptions right, and we strayed. So it does beg a belief that some folk have suggested our report ignores the evidence. For those folk, it is the very breadth of our evidence base that helps us to assess what some claim to be evidence, but what on closer examination proved to be groundless and at times self-serving assertion. Now, balance matters in the high-wire act of getting IP policy settings right, crafting an incentive for creators and innovators, bringing ideas to market while making sure those incentives don't cruel welfare of the broader community. And that's no mean feat. And the community had a lot to tell us about the balance of IP, and that the balance was out of kilter for some rights. For some, the balance was fundamentally broken, even if it still represented the finest legal thinking of the 19th century. So the inquiry's immediate goal was to work out how to fix that balance or imbalance, but also recognising that mechanisms needed to be put in place to keep the appropriate balance for the future. Perhaps what I mean is best shown by examination of patents. For here we found that too many are granted to low-value innovation, and many are used for less honourable motives. We heard evidence of patents being used strategically to prevent follow-on innovation and stymie competitive forces, to delay the introduction of cheaper generic drugs at an annual cost of $250 million each year to Australian taxpayers and consumers. So we made 7 recommendations to fix these problems, and then to make sure it stays fixed, we recommended an objects clause, a legislated roadmap to future courts on how and when patents should be granted. Now, no one will argue with the principle that patents are supposed to reward socially valuable innovation and inventions, except perhaps some patent attorneys. For the new ideas and ways to implement them are ultimately what drive well-being in society. But in practice, the Commission found a large proportion of patents are granted to very low-value ideas. Think a pharmaceutical of identical formulation to a predecessor, but just a slightly different dosage. Think a pizza box that folds out into a bib. May be valuable if you have teenagers. Now, this isn't a new problem, but it's one that other jurisdictions, like in Europe, and we went to Europe and we spoke to smart folk over there, seem to have had greater resolve to fix relative to Australia. And while there have been local efforts to raise the bar, to make getting a patent harder, we had to assess the assertion that we had actually raised the bar down under by examining the outcomes. Had it made a difference? And in doing so, we discovered that assessing patent eligibility had seen very modest change. We examined the patents for the same innovations that had been granted here and in Europe since we raised the bar. And to be honest, it looked a little more like raising the limbo bar at a toddler's birthday party. No one lost out. For the Commission, getting patents policy right is really akin to the John West business model. It's the fish that John West rejects that makes John West the best. And our original analysis revealed that Australia, despite purporting to raise the bar, continues to grant a lot of patents to innovations that the EU has rejected on the grounds of not being good enough. So there is a long way to go before we are the John West of patent policy. Then there is fairness in enforcement. We heard from participants about the high cost of enforcing IP rights, particularly when a court is involved, and indeed it was a concern of authors with any change to the copyright exception provisions. One participant described the situation as, we have a Rolls-Royce system called the Federal Court. You go there, the starting price will be $200,000 minimum, take it from there, $400,000, and then you might have the costs of the other side. Now, a lot of IP disputes that we heard about don't need the Rolls-Royce. They can actually make do with an agile, speedy Vespa. So to alleviate these costs, we drew on the experiences of the UK's Intellectual Property Enterprise Court. My fellow Commissioner Jonathan Coppell and I actually travelled to the UK and we met with Justice Richard Haycon, the head judge of the UK IPEC. And it was a terrific and frank and robust meeting where Justice Haycon really conveyed to us what we needed to know beyond the research. Why the UK model has worked where others had floundered. By capping costs, trial times and damages, dispute resolution costs are reduced and firms have greater certainty. But most importantly, it was the separate list that allowed him to have discipline and a low-cost DNA. And it's for this reason that we recommended that the government should introduce a specialist IP list, a funded specialist IP list in the Federal Circuit Court, encompassing features similar to those of the IPEC. For such a low-cost DNA appears to be alive and well in our Federal Circuit Court. And contemporary research from the UK actually shows the IPEC model is delivering access to justice to a large number of creators and authors that would never have defended or challenged rights in the past. Now, enforcement might sound a bit tedious, but it is at the end of the day an enduring element of what is fair and what is good public policy. So again, we return to this issue of equity. Access to enforcement is actually access to justice, alike for authors on copyright and firms, especially SMEs and new entrants, for patents, design rights, trademarks. It's also a way of future-proofing IP policy so it remains fair, balanced, and in the interest of the community today as well as tomorrow. Now, at this point, you're probably thinking of coffee, but you're also quietly thinking to yourself, I thought I was attending a conference on fair use, but now I'm being lectured on about patents and enforcement. So let's turn to copyright. Our patent recommendations were largely about addressing what is perhaps best described as an unfinished business, a material residual imbalance. In contrast, we found our starting point for copyright policy was arguably about trying to find any semblance of balance. Term at life plus 70 years and scope with our current fair dealing exceptions are not balanced and are firewalled from change by international agreements, although we have found some wriggle room. But we looked and found those areas where meaningful reform can and should be made. Thanks to geo-blocking, Australians pay more for digital content, around 67% more for music, or get less or later access, like the diminished library of titles available on Netflix in Australia relative to the US. And you kind of know something is amiss when the haves and have-nots are delineated by who has a teenager in the home capable of circumventing the geo-block. Mine has moved out. We heard from many participants there is legal uncertainty about the ability for consumers to access legitimate overseas content. And this is the only fair and indeed workable way or weapon to counter online piracy. Creating fair access and eroding the unfair geographic price discrimination that is geo-blocking. So we recommended that consumer rights be clarified, and this also applies to ensuring that rights holders can't contract around copyright exceptions or rely on TPMs, technological protection measures, to prevent legitimate uses. Turning to copyright collecting societies. Now, they play an incredibly important role for rights holders, and they can make a meaningful difference in lowering transaction costs for authors, creators, and content consumers. Indeed, after the inquiry, I told my daughter, who's a writer, to sign up. But they can also wield market power, and this does lift the governance high bar for what we need to see from a transparency and accountability perspective from these agencies. There have been questions that were raised with us in this inquiry about the effectiveness of the Code of Conduct for collecting societies. And we learned in our meetings with UK and European experts, and even their collecting societies themselves, that they had lifted the governance code bar in a substantive way, and in their view, well above the Down Under Code of Conduct. So we recommended that the ACCC review arrangements for collecting societies with a view to strengthening governance and transparency, ensuring that the current code represents contemporary and international best practice in substance and form, balances the interests of societies and licensees, and whether the code should be made mandatory, which it is not today. For at the end of the day, and as a de minimis for us, you need to be able to follow the money. And we couldn't, and nor could right holders or right users in the evidence that we received. Turning now to the myth-busting part of our inquiry, and here it seemed like a monumental sand dune that we had to traverse of argument and assertion. 3 steps up and 2 back. And this was especially the case when it came to the mooted change to copyright, and especially parallel import restrictions on books and fair use. The inquiry was told definitively by publishers that parallel import restrictions do not raise book prices, and was provided with some purported evidence to that effect. But on closer examination, this just didn't stack up. So the Commission purchased data on book prices, compared more than 1,000 like-for-like titles in Australia, the UK and the US, and found that books were indeed more expensive for Australians, by around 20% on average, than in those other jurisdictions like the UK. Myth busted. The inquiry was then told by publishers and authors that parallel import restrictions are crucial for local markets and to support local authors. But alas, this stumbled in considering the workings of markets. For PIRs don't just apply to books by Australian authors. Hilary Mantle's books get the same protection as Hannah Kent's, with the benefits largely going to offshore authors and publishers. So PIRs are effectively a tax on readers in Australia and the publishers the Revenue Collection Agency. And the higher costs of books are borne by all Australians, from bibliophiles to the students, as they or their parents are forced to pay more for Harry Potter, Diary of a Wombat and the dreaded textbooks. And we know from our previous analysis that from the annual $25 million book tax from PIRs, around $15 million flows offshore. So it's hard not to view PIRs as anything but the least effective way to support local authors, and perversely at the expense of local readers. We then thought, well, let's try for a workaround. Let's limit PIRs and their tax imposts to only the books of local authors, so at least the support is targeted. Although we're still not quite sure how much of this the authors see, and I'll come back to this later. But alas, the shackles of our international agreements have relegated that option unavailable for loan. So direct government support becomes the policy no-brainer if the goal is to cost-effectively support local writers and creators without harming their readers, and with the added bonus of cutting out both the middleman and offshore authors. And we explored this angle more in our final report, including establishing that government and ultimately taxpayers provide around $40 million of direct support to local authors today. And on the middleman, we did listen to the case made by locally based publishers that the additional money made from PIRs delivering them higher prices is then used to cross-subsidise local authors. And that's fine. So we requested this evidence. Show us the money and what you do differently to your counterparts in the UK and Europe and the US. But here we were met with the sound of deafening silence. So again, we could not follow the money, myth busted. The inquiry was then told that removing PIRs destroyed the New Zealand publishing sector and decimated New Zealand authors. Indeed, based on some of the submissions and commentary made to the Commission, one might expect that literacy had all but vanished in Middle-earth. But then the inquiry looked closely at these claims. Firstly, the timeline just didn't stack up. A gap of more than a decade between PIRs being removed in 1998 and the global restructure of the publishing sector, which unsurprisingly reached New Zealand given its market size and locale. Moreover, the removal of PIRs in New Zealand doesn't appear to have had significant negative effects on domestic creative effort in the book sector. Analysis by Deloitte Access Economics in 2012, some 14 years after the PIRs were removed in New Zealand, found that the number of New Zealand book titles that published annually had remained fairly steady. But more importantly, data on the number of authors shows that following the reform, the share of authors in overall employment had increased in New Zealand. So rumours of the demise of Kiwi authors are just that, rumours, and not evidence. Myth busted. The inquiry was then told that removing PIRs would lead to the dumping of cheap books printed overseas into Australia. Again, we asked for US-based evidence from the publishers that they purported in our public hearings, but again, all we heard was the sound of silence. It's a hard task to check something that hasn't happened, but the Commission examined the claim by looking at who actually publishes what in different markets. Using more than the 1,000 like-for-like titles across the Australia and UK markets, we found that about 95% of books were published in both markets by the same publisher or subsidiary. So the threat that you'll materially erode your own profit margins if you don't get your way is not the most compelling business case, nor corollary public policy argument, so myth busted. The inquiry then turned its attention to fair use, where the same underlying issue of imbalance persists, but it is a faster growing divide. In a nutshell, the existing fair dealing provisions provide prescriptive exceptions to use copyright material, whereas fair use is a more principles-based approach to dealing with copyright exceptions. The biggest difference between the two in operation, fundamentally, is prescriptive exceptions are glacial at best to respond to change, where principles-based exceptions can adapt and respond more readily. The glacial adaptive experience with fair dealing is best captured in legislative refresh around recording shows on VHS and time shifting using PVRs. The family VHS VCR was mothballed down under by the time our Copyright Act recognised its form of copying. So the question is one of whether prescriptional principles is most appropriate in a modern economy of today and tomorrow. And it is here that there's a paramount point of distinction between PIRs and fair use. We know with parallel import restrictions that technology, the digital age and new business models have proved a great equaliser. Digital books, real-time publishing like we're seeing in Europe, will continue to discipline the price premium local publishers will extract with PIRs. So perhaps where we find ourselves today with PIRs costing Australian readers around $25 million each year is about as bad as it'll get. And while technology in the digital age reduce or constrain the cost of PIRs, the same cannot be said for our system of copyright exceptions. And here's the policy rub, and where the greatest policy imperative looms for our government today. For the inequities and costs of fair dealing are growing and will continue to do so with technological and digital advances. So it's critical to put fair use very closely under the magnifying glass. It also required the heavy glassed frames of the mythbusters. One claim was that fair use would lead to increased court costs and uncertainty. Now, the question about courts and uncertainty is a complicated one. So we consulted widely on the issue, and the community-wide response was far more negative about the existing regime than one of fair use. We heard stories about librarians being unable to provide material to the community due to uncertainties around fair dealing. The Commission heard about the gains that could be made by greater use of grey literature to which fair dealing does not extend. The Commission heard how fair dealing was constraining and costing our local documentary filmmakers. The Commission heard directly from Universities Australia about how institutions were reluctant to use material for MOOCs because fair dealing might not extend to them. The Commission heard about how the status quo meant that millions of dollars of public funds, taxpayers' money, are spent each year to pay licence fees for freely available internet materials and even thumbnail images of book covers so that they can be used on school intranet sites. Written evidence from the Council of Australian Government that Australian schools are paying the Copyright Agency over $9 million each year for material that is freely available on the internet. And we know there is a further $11 million each year that the agency collects and cannot redistribute. So it goes into a pool to be distributed to members who were not the creative originator. On listening to the full spectrum of consumers, creators and curators, the story that emerged was one where the status quo was anything but uncertain and inefficient, and in spite of the name, really anything but a fair deal. The real question then is, could fair use be worse? Having already addressed some concerns about court costs and access to justice separately, it then really becomes a question about whether it's appropriate for rights holders or for content users and ultimately an impartial third party like a judge to determine when an exception to copyright should apply and when it is fair. Under the model proposed by the Australian Law Reform Commission and endorsed by our inquiry, fair use in Australia would use 4 fairness factors: purpose, nature, substantiality, and the market effect. Now, courts are well versed in applying principles-based law in many areas, such as consumer and employment law. And we also met with some very smart folk from the US who showed us very down-to-earth practical guidance material on how teachers, libraries, librarians, businesses can use guidance material to confidently apply such factors to their very day-to-day lives. And these guidance notes, which abound in the US, could be readily applicable here. And in the Commission's view, there's ample evidence, both at home and abroad, that with such guidance the community can be trusted to employ fair use fairly, myth busted, and with a modicum of certainty. Another simpler myth to bust is the claim that fair use is really free use. This is actually simply an oxymoron. It cannot hold as an assertion because of the 4th principle, market effect. The market effect on rights holders is a key component. It's really the foundation stone of the fairness factors and what's allowable. So a use that erodes the market potential for a creator is simply not allowable under this principle. So we asked the publishers and authors to give us examples of what they are being paid for today under fair dealing that they would not be paid for tomorrow under fair use. And we either heard stony silence or we heard of two US examples, Google Books and the case of the transformative wrapper. They argued that Google's open slather digitisation of US library books is tantamount to free use. But the US courts did not agree with this portrayal. They instead found that Google's library project did not provide the books in their entirety as a substitute for original works, and instead only provided very small snippets. And most importantly, in assessing the fourth fairness factor, the effect of the use upon the potential market for or value of the copyrighted works, the courts found that the snippets did not fall foul. Where the snippet view provides a researcher or a student with all the information they need to know, and they don't then need to go and buy the book in its entirety, the courts examined the evidence and found that this type of information was most likely to be factual in nature and therefore not even subject to copyright. Moreover, if you step back for a moment, as we've been asked to this morning, and think about what the Google Library project represents, it is no more than the 21st century equivalent to browsing in a bookstore. So Google is supporting book markets and thereby authors. Myth busted. It was then claimed that fair use destroys publishing industries and has done so in Canada, and particularly their educational resource sector. That claim didn't stand up to even modest scrutiny. The experience in Canada has been grossly misrepresented here and ignores specific market factors there. To begin with, Canada doesn't even have a system of fair use. They have fair dealing. And our Canadian cousins also jettisoned its educational licensing regime. We have not, we propose not to. But that didn't get in the way of some trying to shoehorn unrelated factors in Canada into a story of potential Armageddon in Australia. And to sell a story of Armageddon, you need a big number. The number that's been oft cited by some local luminaries is that fair use would cost the Australian economy $1.3 billion. The number is based on work by PwC and commissioned by rights holders, and curiously contains the following disclaimer. And I'm going to read it. This report was prepared for those named above. In preparing this report, we have only considered the requirements of these organisations. Our report is not appropriate for use by persons other than these organisations, and we do not accept or assume responsibility to anyone other than these organisations in respect of our report. Now, as the CEO of an economics consulting firm in a previous life, this is kind of a revealing disclaimer. So I read on. I read the entire PwC report cover to cover. And we at the Commission found it to be an accurate disclaimer. But there was, but importantly, there was a PwC economist who did write a little in the report. So there was a modicum of economics, and in particular the following in relation to the effect of Canada's introduction of a broader fair dealing provision for educational material. And I'll let you all read it. Can everyone see that? I'll read it. These impacts, while significant for the industry, represent transfer, i.e. from creators to users, rather than economic costs. That is, if secondary derivative works are not truly transformative, then fair use would merely represent a transfer of supply and demand between various groups within society and would not represent the net new economic growth. So, even if we are to accept at face value our local luminaries' oft-cited cost of $1.3 billion if Australia were to adopt fair use, this actually represents a transfer to Australian readers and consumers of the copyright material. The libraries, the new business entrants, the students, the MOOC makers and the local MOOC recipients. So their big number actually represents a big benefit to many Australians, if you believe the number. So whilst we spent some time carefully unpacking the assertions and claims in the PwC report, and for those that want to know a little bit more about that, you can read our box on page 197 of our report. It has the highlights and it's a sobering read. Late in the day, the inquiry also had access to another resource, a cost-benefit analysis undertaken by Ernst & Young for the Department of Communications. The consultants were getting a fair deal out of fair use. This report specifically analysed the winners and losers from moving from fair dealing to other arrangements, including fair use. But here I have to say, it was actually a refreshing read. It was a considered, albeit incredibly conservative analysis of what might happen today if fair use came to Australia. It was a here and now analysis and not forward-looking. It revealed that there was no immediate Armageddon from fair use. Rather, there would be immediate net economic benefits. And that's before taking into account how the shortcomings of the status quo affect matters into the future. So allow me to share a few forward-looking thoughts, because it reveals that moving from fair dealing to fair use is not a zero-sum game, as many portray. Think, no access to data for data mining means no incentive to the workforce to develop these skills which other jurisdictions are developing in spades. Think, hampering access to cloud computing means that Australian firms and families are left to use inefficient, antiquated systems in comparison to other markets and countries that can make use of the latest technology. Think, schools and universities not paying $9 million each year for material that is freely available. And as flagged earlier, think, providing universities and educators fair and certain access to material for MOOCs will enable a new way to skill and reskill our workforce. And perhaps this is one of the most compelling equity issues hidden away in the fair use free-for-all. For it's not just about the millions of lost export dollars of our universities being constrained and unable to develop and export MOOCs. It's about what's needed to re-equip our workforce to remain relevant. Research shows us today the nature of work is changing, such that education needs to be continuous, and there is the need to make adult learning routinely accessible and available for all. It's purported that a uni student today will have 17 different skill-adaptive jobs, and what they learn at school or university will in no way represent the conclusion of their formal learning if they are to remain productive and, more importantly, employed. And if you think of the structural changes in today's labour market, mature age workers facing or avoiding a redundancy, today's workers will need to readily tap into new ways of learning. And we see MOOCs playing a vital role in doing so, and fair use in Australia will play a vital role in making sure they can. Think, Israel. In introducing fair use, did so with a mind to what would be a future benefit to creators, innovators and educators. So the world's cultural and innovation pin-up country gets it. Indeed, it cast its policy narrative in this very way. And if we are to be a truly agile economy, this is a policy change that lends itself to an incredible positive policy narrative. And the narrative flip side is that fair use policy is a policy lever to avoid the looming education divide of haves and have-nots. Nor do we need to reflect for too long to see what political and policy outcomes await us if we allow that to happen. So you can see why there is no single big number of benefit, because at the end of the day, doing such an analysis is complex and simply doesn't lend itself to a single number. But what we do know is there is no Armageddon, and there are benefits to be had, and they reside where the interests of innovation and equity coexist. And we know that these benefits can only grow in the future as technology evolves, but perhaps more importantly, so will the costs of policy failure if we do not jettison fair dealing to the mothball-smelling attic alongside the VCRs. So I hope today's tales of myth-busting reveal less a case of the Commission's ideology, as some have suggested, and more an open mind we try to bring to bear when considering public policy change. We asked, we listened, we evaluated, using work in the public domain, international experience, work commissioned by the Australian Government, work commissioned by publishers, work commissioned by others, and our own analysis, in order to determine which arguments are wolves in sheep's clothing, and which we can rely on to frame policy that makes a positive difference for all Australians and not just a few. And our resulting recommendations to remove parallel import restrictions and introduce an exceptions regime of fair use are based on evidence and with only the interests of all Australians, not just a few in mind. So this inquiry's story ends with a suite of policy change across all forms of intellectual property, some 25 recommendations that we have made to the government, and taken in their entirety, they represent an opportunity to deliver tangible benefits to most Australians, and not just a few. Consumers and content-using businesses would benefit much from fair, certain, and for books cheaper access to content and creative endeavour. Government and ultimately taxpayers will benefit from a substantial reduction in health costs. Think $250 million each and every year, by constraining the costly and strategic use of the PBS with pharmaceutical patents. Rather than hindering innovation and creativity as claimed by some participants, IP reform would also invigorate innovation and competitive forces. Australian firms will be able to take full advantage of opportunities in cloud computing solutions. Medical and scientific researchers will be able to better utilise text and data mining. Unis and TAFEs will be able to flexibly offer MOOCs. And importantly, workers needing to remain skill relevant, whether due to age or structural change, will also have access to skill adaptive MOOCs. Innovative SMEs will be able to innovate without fear of infringing frivolous or strategic patents and be better able to enforce legitimate rights through low-cost dispute resolution. So all in all, you can see there's a really compelling policy narrative to be had here, if people want it to be had. So on a concluding note, let me share a snippet I chanced upon recently, and it's not from Google. In the very first essay of the Copyright Treatise, What If I Could Reimagine Copyright? And authored by the book's editors, Professors Giblin and Weatherall, there is a heading, and it is, "The Public Interest, Please Don't Stop Reading." It made me pause and reflect on our inquiry report and of the words of Theodore Roosevelt, the man in the arena, who spends himself in a worthy cause, but if in doing so he fails, he does so by daring greatly. For in the arena of copyright policy, perhaps our final chapter of our inquiry report should have been entitled, "The Public Interest, Please Don't Stop Believing." The challenge for policymakers today is to focus on the near silent majority of users, of adapters, of educators and creators that will need fair use to bring the next wave of innovation, jobs and equitable prosperity. For its absence will simply foster a society of less haves and more have-nots. So for the Commission, fair use has become not a nice to have or even a good to have, but a policy must have. At the end of the day, we asked and answered a simple question: what is fair? Thank you.
So, Karen, thank you so much for that very illuminating discussion explaining the process and the results and the exhaustive steps taken to consider all of the evidence along the way. I'd like to now invite questions. We've probably got time for 2 or 3 questions before morning tea. Lovely, right here at the front. And if you could just start by saying your name and where you're from, as Karen doesn't know all of us.
Kia ora. James from Internet New Zealand. Firstly, thank you for confirming that my country is not a cultural wasteland. You could do away with PIRs and maybe you'd win the Man Booker Prize more often. So you've mentioned the potential for MOOCs and for more ease of documentary filmmaking. I'm wondering if you encountered any examples of businesses people wanted to set up or opportunities that were not happening in Australia but that could under your suggested reforms to copyright.
Yep. This is where it's a kind of a tough gig to hear evidence from the things and from people that can't, businesses that would be created that can't be created because of fair use. I mean, we certainly did hear from some of the large data providers, Google and others, that some of their business models that they use offshore would not be able to have been initiated or launched here. I think the best way that we can see it, though, is looking through to what the end consumer's missing out on, and that's where we could kind of find the evidence, and then you can follow the trail back to the businesses, and that's what I was kind of hinting at the end. So it is about what we can do up in clouds, and it is what we can allow consumers to access. So it's not just consumers having access to those, missing out on those products, it's then the businesses and the jobs that would come when we allow Australian consumers to have that access. So, and this is a tough area, and I know that there's another academic, wonderful academic, Pat, that you're going to hear from later today, who's actually trying to find that sort of silent evidence base that we oh so much need to sort of better explain and better articulate, because at the end of the day, ministers want a big number if they're going to take a little bit of pain on the way through, and the Bunsen burner's been turned up on them. So we do need to try to articulate as clearly as possible what we stand to lose if we don't.
So we do have time for one more question. So again, I beseech our international visitors. I know you're keeping your powder dry, aren't you? Because you have got the next panel. But Michael Geist, could I perhaps put you on the spot? Given the centrality of the role that Canada has had in this public policy debate in Australia, as perhaps Canada's leading expert in this area, do you have any observations about that?
Thanks, Rebecca. You're killing my intervention later. But so I'll mention something that I'm not going to mention, or I hadn't planned to mention before, and that is this challenge of knowing the unknown. Like, what are you losing from an innovation perspective? What are you losing from not having fair use? And Canada is actually a pretty good test model for that too, because our flexible fair dealing is fairly close to fair use, as I'll describe after a morning tea. And we can actually see, in some instances, companies or opportunities that were lost, let's say in the 1990s when we were very restrictive as compared to what we have now. So I'll give you just one example. It's a company that won't be well known here, I don't think. It's called OpenText. And in Canada, it's a reasonably well-known technology company. In the 1990s, they had cutting-edge search technology. And bear in mind, obviously, there were lots of different companies that were moving in this area. They took a look at the market opportunities, and they really saw two. They saw one that could go out and index the internet. The other was they could go to companies themselves and essentially provide intranets and company search technology, document management, and the like. And part of their analysis was from a risk management perspective in a country that was limited by a restrictive fair dealing provision, the internet seemed way too risky. And so they instead moved towards the other approach, company interest search in a sense. Now that's turned into a reasonably good business and they have lots of employees and they've done well, but they're not Google. And when you think of the lost jobs, the lost economic opportunity that happened with that company or another company actually in the video space in Canada known as iCrave TV, which was doing video streaming in the year 2000, 2 years before YouTube emerged. But again, pressure from a copyright perspective ended up grinding that business to a halt. I actually do think that the Canadian experience also provides now some real-world examples where we can look back and then look a little bit forward and see the impact of some of these restrictive rules can have.
Thanks for sharing that, Michael. And I guess one of the things that's tricky when we're doing an inquiry is we've got this 12-month window. And I was saying last night at the launch of the book, it would have been kind of nice if we had another 4 months, because over the summer period, we start to hear from people offshore with some other evidence that we just couldn't sort of lay our hands on, to be able to articulate what's the option that we're missing out on here.
Terrific, great. All right, thank you so much. We're very fortunate to have Karen with us for another few hours. So if you have a wish to introduce yourself, you will be able to do so at morning tea or at lunch. Thank you very much for listening, and please thank our speaker.